And where are you going? What do you want?
Hello and welcome to Trust and Estate Weekly. I'm your host, Kevin Bemmel, and we are here every Monday at 10 a.m. Pacific time, although I guess it really seems like, 9 o'clock Pacific time or something, because we just had a time change yesterday, so I know I'm feeling a little bit off myself. But thank you very much for joining us, and I want to get right into talking with my guests. For those of you who saw any of my shows last week, you know I've been talking about Merrianne every day because I've really been looking forward to speaking with her. So my guest is indeed Merrianne Dean. She is a trust and estate attorney based in the San Diego area. And she also has a specialty additional practice in mediating disputes that arise out of these same arenas. And Merrianne has been at this for quite a long time. But I'm going to let her tell her story. So, Merrianne, first of all, thank you so much for coming on the show this morning.
Oh, good morning. It's a pleasure. Thanks for having me. Well, so my backstory, who am I, and excuse me, and how did I wind up mediating trust and estate cases? Well, I started out as a landscape contractor and then worked for the city of San Diego in the park and recreation and the engineering departments for 14 years. And during that time, I decided I would go to law school. So in 1990, I decided to go to law school, changing careers completely. I worked full-time and attended law school at night, so it took 4 years to finish school. When I got out, my undergrad degree is in business administration, so after I graduated from law school and passed the bar exam in 1994, I started providing legal services to business clients, helping them set their businesses up as LLCs or corporations, reviewing contracts and commercial leases, and I handled some litigation cases for them. One of my clients asked me if I knew how to draft a trust because they'd heard that was a good thing to do and wanted to put their business interests into the trust. Mm-hmm. So I did what every new attorney does and said, sure thing, and learned about estate planning so I could do that work confidently too. That led me to my first probate case in probate court and my introduction to probate court and other trust and estates attorneys. And I found that I really liked this work. So by 1997, my practice was focused entirely on trust and estate law.
Okay.
When I had enough experience doing that work, I qualified to become a California State Bar certified specialist in estate planning, trust, and probate law, and expanded my solo practice into a small firm where we offer our clients legal services in the areas of estate planning, trust administration, probate administration, conservatorships, financial elder abuse, will and trust challenges, and claims involving the administration of trusts and estates. My firm is called Bellator Law Group, and we're based in downtown San Diego. Over the course of my career,
if I can just interject real quickly, you mentioned that you got a specialization in the bar in this. Would you take just a minute or two and explain what that is and how you went about that? Because I think that would be something very good for viewers to know about, that special credential.
Oh, sure. Well, you have to have practiced in the trust and estates area for at least 10 years. So you have to qualify with your experience.
Okay.
You have to be in good standing with the state bar. And then you have to go take and pass a kind of a mini bar exam. It's another test that's most of the day, memory serves. And then at some point later on, they tell you whether you passed or not. And I did, and I got my certification. And to keep that certification, I have to take specific continuing education classes every year that are focused at that level of level of specialization. There's continuing education programs for lawyers generally. There are continuing education classes for trust and estates lawyers or any other specialty. And then there are some that are qualified for legal specialist level education. So that's it.
Yeah, and so that really puts you at the very top of lawyers who practice in your area. It sounds like.
No, yeah, it's a credential that's good to have. Certainly, it certainly um, reflects my level of expertise and experience.
Hmm.
I guess those are synonyms for one another.
Okay, well, yeah. So please continue with your story.
Oh, okay. So, um, over the course of my career, I've litigated countless disputes in probate court and learned about the value of helping my clients reach early settlements instead of taking their case all the way to a court trial. Incidentally, with the exception of conservatorship matters,
Hmm.
all the fights in probate court are decided by a judge without a jury.
Oh.
So, and there's a little backstory to that. Um, there's a case that I won't cite you to where the courts, this California Supreme Court, determined that the juries were making decisions based on what they felt was right versus what was actually the law. And it was interfering with people's right to make decisions about who should receive their property after they pass away, which is absolute. I mean, you can leave your entire estate to the Home for Wayward Cats, and your family has nothing to say about that.
Uh-huh.
Well, they frequently would have something to say about it, but legally, you're entitled to leave your assets entirely to who you wish them to go.
Hmm. Wow.
And juries were, making judgment calls that were contrary to the law. So that happened often enough. So the Supreme Court and the legislature decided, well, we'll just have these decided by a judge, a probate judge
Hmm.
in a probate court, which is different from a regular civil court where people fight about other things.
Right. Right. That's interesting. I never had heard that before. So, I mean, can parties petition for a jury hearing in probate, or is that not allowed either?
No, there is no right to a jury trial unless you are the subject of a conservatorship. So someone has decided that they would file a petition with the probate court, which is the first, that's how you get into probate court,
Hmm.
is you file a petition asking the judge to make a particular determination.
Hmm.
And in conservatorships, what you're asking the court to do is to make a determination that the person that you are identifying as the proposed conservatee really needs help to, they need that level of uh, protection to stay safe and to make sure their money is safe.
Hmm.
And so a proposed conservatee has the right to a jury trial because if you're conserved, you've got some rights that are being taken away.
Right.
So I've been appointed by the court to represent people who are proposed conservatees, and I've only had two of them over the years that wanted to go all the way to a trial instead of resolving the issue with their families. It's usually families that are worried.
Right.
And in both cases, I was able to convince them that having a jury would not be in their best interest.
Mhm.
Primarily because I knew that my clients, my court-appointed clients, they really needed to be conserved. But
Mhm.
my job as a court-appointed attorney for them was to um, advocate what they wanted.
Right.
And so I knew that if we went all the way through a jury trial, they were going to have a jury look at them and tell them that they could no longer manage their own health care, money, um, living circumstances, and that would be devastating
Mhm.
to someone.
Right.
So I convinced them to go with a judge, and our probate judges are very, very kind and understanding and know how to talk to people who are before them
Mhm.
to try and help them understand why a decision is being made in a particular way.
Mhm. And you say that that applies in conservatorships. Does it apply in a guardianship as well?
No, those are different. A conservatorship is a proceeding to appoint somebody to manage the healthcare, living circumstances, and protect the money of someone who's an adult. And that can be somebody who is elderly and starting to suffer from dementia. It can also be somebody who has sustained some kind of a traumatic brain injury and they're no longer competent.
Hmm.
But those are conservatorships in California are for adults. Guardianships are for minors. And
Minors,
so
right?
there can be a conservatorship or a guardianship rather of the person, which is just if there are no parents around, and grandma needs to step in and have all the authority to make sure the kid goes to school and gets to the doctor and is safe. That's a guardianship of the person. But if
Hmm.
the child has money, so for example, if the parents were killed and there's in an accident and there's a judgment awarding the child monetary damages
Hmm.
because they've lost their parents.
Right.
Well, then somebody needs to be appointed as the guardian of the estate for that child until they're 18 years old. Guardianships terminate automatically at 18.
Okay. And is it that it's essentially because the subject of the guardianship is a minor, they don't have really a lot of legal or if any legal rights, and so the rights aren't being taken away, so there's no need for a jury the way there is in a conservatorship? Is that kind of the crux of it, or?
Yeah, that's exactly right. Children are treated quite differently. Another way that they're treated differently is with if you have if you've got an elder who you suspect is at risk and is being abused, you can call Adult Protective Services,
Mhm.
and Adult Protective Services will go and investigate. But if the elder comes to the door and says, "Oh, no, no, it's okay. My grandson is perfectly fine and I don't have any trouble here and we don't need any assistance," um, the Adult Protective Services investigator has to turn around and leave.
Mm.
Because in California, unless you have a conservatorship or some other determination by a judge that you can't manage your own um, finances and circumstances, you're presumed to have full capacity to make whatever decisions you want to and to be held responsible for those. So, but when Child Protective Services is called because someone believes that a child is being abused, they march in and they scoop the child up often if circumstances warrant it,
Right.
because children don't have that right. They're not presumed to have capacity to make decisions because they're not yet 18.
Right. Okay. Yeah, that makes sense. So, um, particularly on the conservatorship side, that would seem an area that is potentially rife for disputes. So, kind of taking us, I know I took us down a little bit of a rabbit trail here,
Okay.
but how did you then get into the dispute resolution side of your practice, which is really the, if you will, the topic that we came here to talk about today, because I think it happens more often, I think, than the average person thinks. And once you're in a dispute in a legal matter, things can spiral out of control pretty easily in my experience. So, um, how did you?
Sure.
Mhm.
So my first introduction to mediation, and mediation is just a process that people can use to resolve disputes. It's just a name for a process, and
Mhm.
I'll get more into that. Let me start out at the bare bones though.
Okay,
My
sure.
first introduction to mediation was when I took an elective course in law school, and that led to me interning with the city attorney's office, where I assisted with resolving neighborhood disputes. So lot line problems, or my neighbors being too noisy, and that whole program is set up to help people avoid going to court with their neighborhood dispute. So I
Mhm.
got to do that as an internship, which was super helpful. So I was already familiar with the process when I first started using mediation to help resolve my own clients' cases.
Mhm.
So after attending a number of mediations as an attorney representing my own clients, I decided to expand my knowledge by taking a specialized training course in mediation offered by National Conflict Resolution Center, which is here in San Diego. That training increased my ability to help my own clients settle their cases because I had, a lot more of the background and the skill set.
Mm-hmm.
The probate court requires everybody, all the litigants, to participate in either a mediation or, for cases that don't have the resources to pay for a mediator, what's called a mandatory settlement conference prior to the assignment of a trial date.
Mm-hmm.
The mandatory settlement conference program is offered through the court, and it's staffed entirely by volunteer attorneys with experience in trust and estate matters, who are familiar with the dispute resolution methods. The family court has something similar.
Mm-hmm.
So these are helpful because oftentimes the disputes involve family members, and so it's a little more touchy-feely.
Mm-hmm.
Some of my own cases benefited from the services of those volunteer attorneys. And, primarily this works the best for, as you mentioned before, conservatorships, where everybody agrees grandma needs to have somebody in charge, but
Mm-hmm.
there's huge disagreement about who that should be.
Ah.
Or there's finger pointing about, the grandson living in the house, is he just a parasite? Well, or the other position is, no, he's really being helpful, so he shouldn't be paying rent. So those are the kinds of fights that arise. There are worse fights involving financial elder abuse and things like that. So conservatorships can really ramp up into some pretty serious claims and defenses.
Mm-hmm.
But for the most part, they, your run-of-the-mill conservatorship where there's only a little conflict are really, really good for mandatory settlement conferences.
Mm-hmm.
So in 2009, I began volunteering with the probate court as one of those, they're called settlement conference dispute settlement conference officers.
Mm-hmm.
They changed the name of what they call us
Right.
a couple of times. So I started volunteering as a settlement conference officer, essentially really returning the favor to, so to speak, because I'd used settlement conferences to, resolve some of my own cases.
Mm-hmm.
And whenever I've got a case where one of the attorneys, or both sometimes, I know these people for years and I know that they have the background and experience to serve. And I always ask them and kind of buttonhole them at the end of the settlement conference and say, so when are you going to sign up to be on the panel? So that we have more people. That work also offered me the opportunity to combine my years of experience as a trust and estate litigator with my mediation skills, assisting other attorneys and their clients in resolving disputes. And I really liked that work. It seems like it's more productive than simply just having a fight.
Mm-hmm.
So I began working formally as a paid mediator through the West Coast Resolution Group, which is also in San Diego, in 2020, and focused on trust and estates dispute resolution. I don't do anything else,
Mm-hmm.
in addition to continuing my trust and estates practice. West Coast Resolution Group is an affiliate of the National Conflict Resolution Center, and they've got a talented team of professionals who manage the scheduling and logistics for my mediations and any others that are done through their organization. West Coast Resolution Group also has an entire floor of conference rooms for use during in-person or hybrid mediations.
Mm-hmm.
And I'll explain more about what those are in a minute.
So if I can just interject a question here, and
Sure.
when I talk to just people in general, as I'm sure you're aware, lawyers don't have the greatest image with the public, and I in my experience, and this is not me, currying favor, I assure you, but in my experience, I think a lot of that comes from the way lawyers are portrayed on television. They're very sort of, mercenary and all those things, and so I can imagine for some of the people watching this idea of lawyers volunteering, and when you say volunteer, I assume you mean unpaid, to help resolve, disputes. so that people can go on about their lives in a more congenial fashion and not blow all their money on lawyers' fees. I can imagine some people are, I don't know, skeptical about that, or why would a lawyer do this? So I'm wondering if why do lawyers do this? And I'll just add real quickly, one of the reasons that I always enjoyed working in the trust and estates arena, and it dates back to when I had my real estate company, is I generally found that lawyers who practice in this area are among the best, most empathetic legal practitioners that I've ever dealt with. They have a high fidelity to taking care of their clients, oftentimes in a way that probably wouldn't be to their own best interest, if you know what I'm saying, but they do put their clients above all else. So I'm curious about your thoughts on that.
Well, I'll tell you one of the things that attracted me to the probate bar, meaning the attorneys who practice in probate court, is that we do get along. Collegiality among professionals really does happen there. We, for the most part, we get along. There are a few attorneys that I don't really trust completely, but for the most part, it's your word is your bond. And if another attorney that I know in probate court tells me they're going to do something, they're going to do something. The other thing is that we're very collaborative. We have an entire committee. It's rather a large committee at this point. It's called the Bench Bar Committee, and we meet every other month with the judges and the court staff and the attorneys who work in the probate arena. And the purpose of meeting together like that is to identify things that need changing to make the whole process of probate court more accessible to the actual consumer, the user, our clients, and to make procedures easier for attorneys to follow so that we're more efficient. And so that's really kind of a remarkable thing. I've talked to some of the judges who sit on benches in civil court, and they've expressed admiration that the probate court has this, cooperative. I don't know. I'm grasping for words right now, but the fact that everybody gets along, that the probate judges have this resource, and so the court cases just typically will move forward more efficiently. And that is one of the reasons why the probate judges or probate attorneys are willing to sit on this panel for mandatory settlement conference resolution, because we take care of one another. We help one another settle cases. We get things done. The court's got its own. Generally, the courts have a vested interest in getting things settled before having a court trial, because they're backed up. The probate court is terribly backed up at this point, because the demographic in our state is aging out, and so there are just more conservatorships, and there are more fights over decedents' estates as people pass away. So if a case gets settled in alternative dispute resolution, meaning either a mediation or a mandatory settlement conference, then it's one less case for the judge to have to track. So, but why do people come and do this? Well, what are the benefits? Well, to begin with, it's important to understand that only people who enjoy litigation, the only people who enjoy litigation, are the attorneys and their staff. I mean, really. In fact, nobody wants to be sitting in an attorney's office unless they work there, right? Or they have friends who work there, or they provide services to the firm. Even getting an estate plan done can be uncomfortable, because you have to face the fact of your own mortality. And of course, attorneys are expensive. So people who find themselves in the middle of a dispute where they need the help of an attorney are facing one of the most stressful experiences in their lives. And I firmly believe that an attorney's role must be to help their client understand the law that applies to their situation and the procedures required to deal with their problem and to protect their rights.
Mhm.
However, that role must also include the ability to help clients resolve disputes efficiently. And by efficiently, I mean with the least possible financial and emotional cost to the client.
Mhm.
I have little respect for attorneys who actively escalate conflict because that's better for their own bottom line. They do exist, and they give the rest of us a bad name. It's really interesting when we see civil attorneys who see that there's all of this work that's starting to be available in probate come over and they want to play LA law in the probate court, and the judges just kind of look at them like, "What's wrong with you?" Because we have this collegiality and there are rules that govern how probate court works, and it's different than civil.
Mhm.
Litigation itself is complex, it's time consuming, and it's astonishingly expensive.
Mhm.
There's very strict rules that govern how a court case proceeds, from the first petition or response, which are the documents that people will file to get the court case going. A petitioner is asking for specific relief or an order from the court, and a respondent is typically saying, well, no, that's not right, and I object. So those get filed with the court, and then there's a lot of work that gets done all the way through to a trial before the probate judge. It's not uncommon for a trust and estates case to take up to 2 years to complete, and the price tag for all of that work can easily exceed $100,000 or more.
Mhm.
So there's a monetary benefit to resolving cases early. There's an emotional benefit to resolving cases early. Litigation also carries considerable risk. You know, you think you're going to march into court, and I'm on the side of the angels, and I've got all of the witnesses and all of the evidence, and so I should carry the day.
Mhm.
So you've got to work your way through that, or your attorney has to work to identify that evidence, identify the witnesses, get everybody teed up and ready to present in court. This creates variables that are often beyond the control of the client and their attorney. For example, nobody can guarantee how well a person will perform when they're sitting in the witness box.
Mhm.
Witnesses, well, unless they've done it before over and over and over. Some people are just, routinely in court, and so they develop skills. But most witnesses are lay people who just know things about a case. Witnesses who present as confident and credible when they're initially interviewed by the attorney often experience significant stress as the trial approaches. They know that their testimony is going to be important to help the person that they're testifying for win the day.
Mhm.
They can become so flustered that they don't sound nearly as credible on the witness stand as they did sitting in the lawyer's office. I had one personal, I'll tell you a war story. I had one case. I was representing a young man who had been um, gifted some money from an elderly person who took a liking to him. And that elderly person's family objected to that. They thought they should be getting the elderly person's entire estate, and this young fellow should not. We prepped the case. We couldn't get it resolved in mediation, so we had to take it to trial. I had one witness who was really kind of a third party, got no dog in the fight, um, just knew things
Mhm.
and personally familiar with the elderly person and the circumstances. And she did great. Her deposition was taken, and that's testimony before in a conference room with a court reporter, and the person's placed under oath. And so the lawyers get to ask that person questions in advance of going to trial. She
Mhm.
did wonderfully in her deposition, rock solid.
Mhm.
We got into court. We're in the big formal courtroom. The judge is up on his bench. She went and got in the witness stand and melted down. She was a deer in the headlights. And
Mhm.
that judge came back at the end of the case and ruled against my client, and
Oh.
um, explained that he was, oftentimes the judges will explain their rulings, and he said that one of the things that factored into his decision was he didn't really believe this witness.
Mhm.
So
Wow.
the wild card, that's another wild card, not knowing how the judge is perceiving the witnesses and how he or she are gauging the credibility of the testimony. They're
Mhm.
really good. Judges all have an excellent poker face. You can't usually tell what they're thinking as they're hearing the evidence because they have a legal obligation to be completely neutral until they hear all of the evidence. So,
Mhm.
so you can't tell.
Mhm.
A case that seems rock solid can crumble away during the trial simply because the witnesses for the other side are perceived by the judge to be more credible. Trials result in rulings where one side prevails and the other side loses. And the judge must follow the law exactly and can't be creative with their rulings. So, how can we mitigate this risk? Well, obviously, by reaching a settlement through mediation with the opposing party as early in the case as possible. That's how.
Mhm.
The parties in a mediation do have the ability to craft creative settlements that avoid the win-lose scenario. As I mentioned before, the courts are heavily invested in ensuring that parties in litigation participate in settlement efforts. So, that's encouraged. So, what's the mediation process? Well, mediation can occur even before a case is ever filed in court. In fact, some parties who are able to handle settlement negotiations directly because they're still actually speaking with one another can often use the help of an experienced attorney or a mediator who can serve just as a coach to help them frame their positions. Even cases that do wind up in court can benefit from early mediation once both sides are clear about their own position and that of the other side. So, and how do they do this? Well, the parties will want to conduct limited discovery before going to mediation to make sure they understand the other side's position. And what is discovery? Discovery is simply a process where the parties exchange written questions and answers, and sometimes also includes taking depositions that I mentioned before. Um, and the questions and answers taken down during a deposition, they're taken down verbatim by a court reporter and turned into a printed transcript that people can use.
Mhm.
So once that limited amount of discovery is done, everybody knows what the other side's position is. Pretty sure they know what all of the testimony and evidence is going to be. Then they can go to mediation with their eyes wide open.
Mhm.
So when the attorneys are confident they understand the other side of the case, they will confer and they will choose a mediator who has a good reputation and knowledge about the area of law that relates to the case. The mediator's staff then take over and coordinate dates to schedule the mediation. Now, how does this take place? Well, with the overwhelming adoption of Microsoft Teams and Zoom and other um, online options, mediations can be done remotely. And this is convenient when the parties live in different cities or states. The courts now offer some kind of remote video appearance option for hearings too. So attorneys are quite comfortable with this. Many people feel that in-person mediations are more productive, um, where the parties all show up at one location and they get placed in different conference rooms, but they're there in person. And I agree that's true for some cases, but not all of them.
Mhm.
Some people who are elderly or are otherwise immune compromised may want to avoid the risk of catching COVID or some other respiratory disease. Some people are also better able to participate in a day-long mediation if they're in their own home with a comfortable chair, their kitchen, and a restroom nearby.
Mhm.
Also, as I mentioned earlier, we had one case where the woman wanted to stay home um, because she needed her dog,
Mm. Mhm.
and her dog wasn't a certified support animal, but that dog was so important to this woman that everyone agreed, okay, great, we'll zoom into you and your dog can participate.
Mhm.
So as I mentioned earlier, mediations can also be hybrid with a combination of in-person and remote participants. So you can
Mhm.
have a bunch of people at in the conference rooms, and then similar to this, have some folks streaming in and participating that way. So it's really quite flexible.
Mhm.
Once the mediation's been scheduled, the parties exchange mediation briefs, which is, written document. It could be a letter, it can be, more formal, where they provide a description of the case and identify the law and the evidence they think is compelling and supports their side of the dispute. The mediation briefs are also sent to the mediator in advance of the mediation. So when I mediate a case, I get the mediation briefs and I read them.
Mhm.
And then I schedule short individual meetings with each attorney. And if there are people who are not represented, then I'll have that meeting with the individual who's not represented. It's called pro per.
Mhm.
After I've looked at the briefs, I use these advanced meetings to gain some insight into the parties, their personalities, confirm that the attorneys have explained the mediation process to their clients, and learn about any prior settlement negotiations that might have happened. I also confirm that the attorneys have discussed the risks of litigation and benefits of settlement with their clients, because I want them coming to the table kind of pre-educated in why they're there.
Mhm.
The day of mediation, I start out by meeting briefly and privately with each party and their respective attorneys. So Zoom has the ability to create what are called Zoom rooms,
Mhm.
where people can. So I set up several Zoom rooms. One party and their attorneys are in one Zoom room, another party and their attorneys in another Zoom room. So I will bounce back and forth between those rooms, or or maybe physical conference rooms if it's a in-person mediation. But in any event, I start out by meeting privately with each party. And I go over the rules around confidentiality and how the mediation will progress, just to make sure everybody's on the same page.
Mhm.
Incidentally, everything about a mediation is confidential, from the briefs to everything said by anyone during the mediation. Um, in fact, it's important to include a provision in any written settlement agreement that confirms that the agreement is not confidential. And
Mhm.
the reason for that is because people who feel safe are more willing to be open about their feelings and their perspectives. So if they know that, for example, there's case law that says mediators cannot be pulled in as witnesses and be forced to testify. Just it can't happen.
Right.
So next, I spend time with each side, starting with the party who brought the case to court in the first place, and just listen to them. My initial goal is to give each party the opportunity to tell me about their side of the case in their own words. And hopefully, I'll be able to identify any areas where they might be able to agree before moving on to the areas where they're in sharp disagreement. So, for example, um, when the dispute involves claims that one side has acted improperly or stolen money from an elder, or even if it's just a conservatorship dispute over who's the best person to be appointed, it's really common for the parties to agree that the central focus is making sure the elder is safe and being cared for properly. So establish areas of agreement and develop rapport with the parties. Another thing that I'm clear about is that I'm a neutral. I'm not making any decisions. I may have opinions that I could offer if asked, because I have experience in this area of law, but I'm not calling balls and strikes. That's for the judge to do if the case doesn't settle. My only role is to help people understand their position, identify potential settlement options, evaluate uh, offers from the other side, and create counter offers. And that's all I do all day long, back and forth, back and forth. It's called shuttle diplomacy.
Mhm.
So I reiterate the benefits of reaching a settlement during the mediation and the risks of taking the case to a trial. An important factor that I emphasize is the financial and emotional cost to each party if they continue the dispute for another 6 to 12 months. Now, having confirmed that their attorneys have already told them about this is just reiteration that's helpful.
Right.
Peace of mind and the ability to return to one's own life without waking up and worrying about the case first thing every morning and last thing at night, turns out that has significant value to most people.
Mhm.
So Many times the attorneys want me to share my personal experience and insight into their client's dispute to kind of give them a different framework.
Hmm.
Um, so if I'm asked to do so, I will identify what I see as strengths and potential weaknesses in each party's position that would support reaching a resolution. I can share, as I just did a few minutes ago, how my own cases have taken unexpected turns, um, and emphasize the uncertainty of how the judge will evaluate the evidence.
Hmm.
Mediations generally require at least a full day to complete. People don't go into mediations thinking, well, we'll do this for an hour and it'll all be good. It takes a while, simply because the parties need time to tell their story, consider offers, make counter offers, consider creative solutions. My role is that of a shuttle diplomat and help them do this.
Hmm.
Parties also require time to consult with their counsel privately after receiving an offer or a counter offer. And so I will step away and let them talk to their attorneys, and then I'll step back in
Hmm.
and assist them with whatever they need. Usually it's to craft a counter offer to the other side's most recent offer.
Hmm.
Ultimately, I'm happy to say that the vast majority of cases I've mediated, both as an attorney representing a client and as a mediator, have resulted in settlement and a written agreement. And by the way, the other topic I discussed with the attorneys during the pre-mediation meeting is my expectation that they will work together before the mediation even takes place to prepare a written settlement agreement containing all the legal provisions that they think it needs,
Hmm.
and only has a big hole where the specific settlement terms can be inserted.
Hmm.
Why do I require this? Well, I found that waiting until the end of mediation to start discussing how the settlement agreement should be drafted can derail settlements because the parties are often physically and emotionally exhausted if the thing continues on long enough, and they want to be done with it. They don't want to sit there for another hour waiting for their attorneys to argue over paperwork.
Hmm.
Also, I want a written settlement agreement signed before they leave, and I require
Hmm.
that because buyer's remorse is a very real thing. And we don't want to have a mediation that results in a settlement blow up because somebody goes away and they talk to some family member who didn't participate, who says, well, gee whiz, you got screwed and you should have done this.
Right.
That's it in a nutshell.
Hmm.
Um,
So, what do you find? You mentioned that the vast majority of the cases you've been involved in, both as a mediator and a lawyer, you've been successful in settling. So, what seems to be the key reason or reasons that mediation doesn't work?
Sometimes people are just so mad they can't get past it, or they're the kind of a person that just wants to fight with someone. They're a perennial bully, and that is their modus operandi. And so, if you don't have two reasonable people who value the notion of getting on with their lives and reaching a settlement, you can have a case that's impossible, and then it just has to go to court.
Hmm.
The whole reason for the court system, honestly, is to keep people from acting like the Wild West.
Hmm.
Nobody, you don't have to pick up a six shooter and go after the person you're mad at if you can take them to court instead.
Right.
And so that's what the courts exist for. And the judges are perfectly happy to fulfill that role if they must.
Hmm. Interesting. Interesting. So, um, you mentioned that litigation can easily cost, $100,000 or more, in terms of, the cost to get through it. What would be a range of costs by comparison that someone could expect, in mediation, in your experience?
Well, it depends,
Yeah.
which is the answer to every legal question,
Right.
right?
Right. Uh-huh.
Um, so mediation itself, if you're going to go a full day with an experienced mediator, you can plan on the parties jointly spending $5,000 or $6,000 for that process,
Okay.
um, and whatever it takes to to get to that process, whether they do it before litigation or they do it after they've done some discovery, whatever the attorney is charging is another expense.
Right.
But I guarantee if you get in early enough and you really are committed to reaching a settlement that's in everyone's best interest,
Mm-hmm.
it's not going to cost anything like what litigation requires.
Mm-hmm.
And it's said that a successful mediation is where both parties walk away a little disgruntled. They didn't get everything they think they're entitled to,
Mm-hmm.
but they got what they can live with. And in particular, they got their peace of mind and their lives back. So that's a successful outcome usually.
So that's Halloween just passed. I had in the back of my mind, I have an attorney friend who tells me when he negotiates a solution between two parties, if both parties walk away a little bit miffed, he can be reasonably confident the agreement is going to stick. But if one walks away thinking he's triumphed and the other one thinking that he got totally taken advantage of, that agreement is almost for sure going to fall apart. So it's interesting that you express that same philosophy, because it makes sense. Both sides have to be willing to give at least a little bit beyond their comfort zone, probably, to reach a successful conclusion.
Right, and yeah, every case is different. What are the factors that a party can be convinced to give up?
Mm-hmm.
It varies.
Yeah, yeah.
So, and that's why I require a written agreement signed by everybody before they check out.
Mm-hmm.
Because, as I said before, somebody who feels like they got a reasonable settlement can go talk to some well-meaning or maybe not well-meaning family member or some friend who thinks they know everything,
Mm-hmm.
and buyer's remorse can set in. Well, if there's a signed agreement, that's legally binding.
Mm-hmm.
And that settlement is not going to derail. And if it does, the settlement agreements usually contain a provision that allows a judge to settle any kind of dispute about the agreement itself,
Mm-hmm.
which is a much faster proceeding. Usually, the parties go in and they argue, well, why they either have or insist on settlement being enforced, and the judge will think about it and then issue a ruling, and boom, we're done.
Right. And does the agreement that is drawn up out of the mediation, is that typically entered into the court record, as some sort of on a petition or something like that, or is it kept private between the parties? And as long as the agreement is lived up to, then the court matter is I don't know, dismissed, or how does that sort of wrap up work, assuming that there was that the mediation came out of something that was filed in court as opposed to being conducted before parties got to court?
Well, the parties can agree on whether the settlement agreement needs to be filed with the court. In cases where there are some key players who are doing the work of reaching a settlement and they brought the case to court in the first place, but there are some sort of ancillary people hanging out there, folks who might have a contingent interest in a state or something, but they have not bothered to participate. Sometimes it's the better plan to file yet another petition with the court, only this time seeking the court's approval and confirmation of the settlement agreement. And then all these ancillary people get a copy of that petition, and they have an opportunity to be heard before the court. And then if that settlement becomes a court order, then it's binding on everybody. And that's sometimes helpful. Not all cases require that, but it's certainly an option. Sometimes the parties don't want to file the settlement agreement with the court, but there's a provision that says that the person who filed the petition in the first place will now go and ask the court within 15, 20 days to dismiss their petition and take the whole thing off the calendar.
And will they be required to dismiss with prejudice necessarily? Because if I'm the party who's been sued basically, and now we've reached a settlement, and for maybe we're not going to enter that settlement, have it entered into court. But on the other hand, I don't want to be in a position where the suit is withdrawn without prejudice, and now I can get sued again and have to be forced to go through the whole process, right? So how is that dealt with?
Well, two ways. Some cases you cannot dismiss with prejudice. Conservatorships can't be dismissed with prejudice
Oh, okay.
because you always have to have the ability for somebody to file another petition to protect an elder. So that's never going to happen.
Okay.
Other cases where it's just a fight over money and there's claims from one side of bad behavior by the other, you can include a provision in the settlement that says, yeah, they will dismiss with prejudice. And that's a technical term that says, if I'm dismissing my case with prejudice, I can never bring it again. Now, that doesn't mean that if the other party does some new skullduggerous thing down the road, that I can't drag them back to court for that new behavior. But everything up to the date of the settlement is water under the bridge, so to speak.
Yeah. And
settlement agreements also usually include kind of mutual waivers saying, I agree that, we both agree that nobody is admitting anything, and we're agreeing that we're just going to dismiss this thing, and we're waiving any liability that we might have towards one another, regardless of what we may find out later, with respect to all of the things that happened up to the date that we signed the settlement. And that's kind of a plain description of a legal concept.
Right, right.
So you can build things in. And that's why I have the lawyers draft these things and collaboratively, because I want everybody to have all of the provisions in place that they think they need to protect their client's rights, assuming settlement's going to be reached.
And as a mediator, what is your posture with respect to, for example, the parties granting mutual waivers or a dismissal of an action that was filed prior to the mediation? How actively can you get involved in seeing to it that those issues are dealt with if for some reason the attorneys don't seem to be dealing with it themselves?
That is not my role. I do not have any role in drafting settlement agreements because I'm not engaged in the capacity of being an attorney. I don't have my attorney hat on. So I'm not going to draft those agreements. I'm not going to weigh in on those agreements. Oftentimes I won't even see them. I'll just get confirmation from the attorneys that they have reached a collaborative decision of what needs to go into the agreement, and it's on them.
Okay.
If an attorney that's called malpractice if they don't do it right.
One would think, right?
And I'm not going to get involved in that. I will tell you that the trust and estates attorneys that I commonly deal with, either as adversaries in probate court or colleagues at bar association events, or as representatives for their own clients in a mediation, they're so good at what they do for the most part that I just don't, it's something I don't even worry about.
Okay. That makes sense. Yeah, no, so, but it's interesting because you strike me as someone who really deeply wants to help people, and I could imagine that if you saw a lawyer not addressing an issue that the lawyer ought to be addressing, it'd be very difficult to sit on your hands, right, and let that go by. But as the mediator, that's what your responsibility is, and so that's what you do.
Right. I mean, that's their job, and this is my job in this circumstance. Now, if I'm representing a client and I'm working with another attorney to craft one of these agreements, and I get a draft from them that doesn't contain something that I think would be important for both of our clients, we'll go back and forth about that. Well, gee, we need to include this because at that point, I'm trying to create a document with opposing counsel that's going to support any settlement that's reached. So
Mhm.
this thing doesn't blow up later on, because it's an awful lot of work to get a case ready and then through a mediation. And you just want to be able to shake your client's hand and say, you did good. You've reached an agreement that I think is going to be beneficial for you and your family. And we're done now. You can stop sending money to me, which makes them happy usually.
Absolutely. So one last question. We've gone a little bit longer than we normally go, but and I could go another hour, I think. But one final question. Um, what are your, let's say, top three frustrations as a mediator or a lawyer who's involved in a mediation?
Hmm. Well, when opposing counsel or one of the attorneys clearly doesn't understand what they're doing, or they're one of those rare people who are belligerent just because that's the way they are in the world, or it helps their bottom line to keep the drama going. When I have one of those kind of attorneys, either on the other side of one of my cases or as a participant for their own client in a mediation, that's a frustration. Having a client who or participant not engaged, they sit there like a lump, they haven't been properly prepped by their attorney, or they're participating in a settlement conference or a mediation because they need to check a box, because really what they want to do is to continue the fight.
Mhm.
That's a frustration. I had one case where the client said, "Okay, well, I'm done here, and I'm going to go off to the bathroom," and they never came back. And the poor attorney is sitting in a conference room, and I said, "Where's your client?" "I don't know."
Oh my.
That was hard
Yeah.
for everybody.
Right. Wow.
So people need to be prepped and ready to with an open mind and understanding the process, and walk into a mediation with the expectation that if everybody works hard, we're going to get this thing settled.
Mhm.
When that doesn't happen, that's frustrating for me.
Yeah. Well, Merrianne, this was really fantastic. I mean, your explanation's so clear, so cogent. I really appreciate you taking the time to join me today, be my guest in talking about this issue. Like I said, I think there's a lot more here, and perhaps if you're available, we'll have you come on again and get in maybe just some of the more the complexities of mediation, and maybe if you're able to share a couple of war stories, because I find those are very useful to help generate ideas on how another case could potentially be dealt with. So
Oh, sure, sure. We could do a whole session on creative solutions.
absolutely. So,
Hey,
oh, I'm sorry. Go ahead. Yes.
so I've provided you with my contact information.
Mhm.
One thing I'd like to specifically point out to your viewers is we have on my firm's website, we have a mediation worksheet that will help people who just want to try and resolve their own conflicts,
Mhm.
work through the kind of questions they need to answer in advance of getting together for that. And that's located at www.bellatorlawgroup.com/worksheet. And it's a free download.
Great. So when the show posts on YouTube, I'm gonna put all of these links in the show notes. So for any
Okay.
of you who are watching, if you want to get in touch with Merrianne, all of her contact information will be there. Her firm's website will be there. I think you also gave me the URL for the mediation organization with which you're affiliated, and
Yes.
I'll put in a specific link also to that worksheet, because I think people will find that very, very useful, and that way people can just click right through to it, from viewing this. So
Perfect.
Excellent. Well, Merrianne, again, thank you so much. If you don't mind just sitting tight for a moment while I wrap up the show, and I'll take us offline and we can
Sure.
say goodbye. So folks, I really appreciate you joining us today. I'm not even going to ask if you got a lot out of it. I know you had to have, because of Merrianne's presentation. So if you're dealing with any of these issues, whether as a professional, whether as a party to a trust or estate matter, I can't encourage you more to re-listen to what Merrianne talked about today. Contact her if it's a situation, you practice primarily in the San Diego area or throughout California?
We practice throughout California with the advent of Zoom and Microsoft Teams, and I think it's Northern California uses Blue Jeans so we can go anywhere without having to get on a plane.
Okay, great. So if you've got a matter in California, I can do a shameless plug because I know Merrianne won't. but give Merrianne a call. I think you can see that her level of client service is extraordinarily high. Now, before we go, real quickly, tomorrow, 10 a.m. is my show, Business Lessons from the Military. And I'm going to be talking about the qualities that are essential to win. I'll be talking about Admiral Horatio Lord Nelson's victory at Trafalgar. And I'm going to be distilling from that the qualities that he had as a leader that was able to lead to this victory, and we'll translate that into how we can apply that to our businesses and practices. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. And I'm going to be talking about one of my favorite subjects, and that is practice doesn't make perfect. I know you were told that your whole entire life, but if you've ever read the book Practice Perfect by Doug Lemove, you will realize that's not exactly how it works. So we'll be talking about how to practice in a way that will actually get you to ever higher levels of success and achievement. And then finally, this is my every other week show on Thursday at 5 p.m., Jiggers' Place. And we'll be sitting back and having a cocktail and talking about, oh gosh, I can't remember what the topic is. Let's see. Yes. We're going to be talking about how to get on the road to happiness. So as you know, on Jiggers' Place, we talk about all the non-professional business matters, talk about the big questions of life and all the important things, relationships and such. So join me 5 p.m. Pacific time at Jiggers' Place for a cocktail and a chat. So one last time, Merrianne, thank you so much for joining me. All of you out there, wishing you a wonderful rest of the day and signing off as I always do. Marie, darling.